Welcome to Middle Class Matters. Today, the 14th June 2023, Business News in English from Dr. CMA MBA Allegation. On the report of the expert committee constituted by the Honorable Supreme Court of India, we will see the continuation of part number 8, para 25. With effect from December 31st, 2018, explanation 1 and 2 in the above definition were substituted. The changed provisions read as follows. Explanation 1. For the purpose of this class, opaque structure shall mean any structure such as protected shell company, segregated shell company or equivalent, where the details of ultimate beneficial owners are not accessible, or where the beneficial owners are ring-fenced from each other, or where the beneficial owners are ring-fenced with regard to the enforcement, or 2. Where applicant or its investors identified on the basis of threshold for identification of beneficial owner have issued any bearer shares or maintain any outstanding bearer shares, provided that the foreign portfolio investor satisfying the following criteria shall not be treated as having opaque structure. That is 1. Applicant is regulated in its home jurisdiction. 2. Each fund or sub-fund in the applicant satisfies broad-based criteria. 3. The applicant gives an undertaking to provide information regarding its beneficial owners as and when board seeks this information. And 4. The applicant submits an undertaking that it does not maintain any outstanding bearer shares and it would not issue bearer shares in future. Explanation 2. The phrase ultimate beneficial owner shall have the same meaning assigned to the term beneficial owner as defined under the Prevention of Money Laundering Act 2002, para 26. The changes were twofold, that is, 1. Introduction of the legal standard that issuance of bearer shares would render the structure opaque, and 2. Adoption the meaning of beneficial owner under the Prevention of Money Laundering Act 2002 PMLA for the meaning of ultimate beneficial owner in the FPI Regulations 2014, para 27. Therefore, while the phrase used in the FPI Regulations 2014 is ultimate beneficial owner, the meaning given to it would be the definition of the term beneficial owner under Rule number 9 of the Prevention of Money Laundering Maintenance of Records Rules 2004 PMLA Rules, para 28. Relevant extract from Rule number 9 of the PMLA Rules, which stipulates that every client must declare as beneficial ownership to a reporting entity, that is the banks and financial intermediaries, is set out below. 1. Every reporting entity shall A. At the time of commencement of an account-based relationship, identify its clients, verify their identity, obtain information on the purpose and intended nature of the business relationship, and determine whether a client is acting on behalf of a beneficial owner BO, and identify the beneficial owner and take all steps to verify the identity of the beneficial owner, etc. 3. The beneficial owner for the purpose of Sub-Rule 1 shall be determined as under A. Where the client is a company, the beneficial owner is the natural person or persons who, whether acting alone or together or through one or more judicial persons, has a controlling ownership interest or who exercises control through other means. Explanation for the purpose of this subclass. 1. Controlling ownership interest means ownership of or entitlement to more than 25% of shares or capital or profits of the company. 2. Control shall include the right to appoint majority of the directors or to control the management or policy decisions, including by virtue of their shareholding or management rights or shareholders agreements or voting agreement. B. Where the client is a partnership firm, the beneficial owner is is the natural person or persons who, whether acting alone or together or through one or more judicial person, has ownership of entitlement to more than 15% of capital or profits of the partnership. C. Where the client is an unincorporated association or body of individuals, the beneficial owner is the natural person or persons who, whether acting alone or together or through one or more judicial person, has ownership of or entitlement to more than 15% of the property or capital or profits of such association or body of individuals. D. Where no natural person is identified under A or B or C above, the beneficial owner is the relevant natural person who holds the position of senior managing official. E. Where the client is a trust, the identification of beneficial owner or owners shall include identification of the author of the trust, the trustee, the beneficiaries with 15% or more interest in the trust, and any other natural person exercising ultimate effective control over the trust through a chain of control or ownership. Para 29. Therefore, what is piquant is that since the inception of FPI regulations 2014, it had been the responsibility of the designated depository participant DP with which the FPI is registered to ensure that FPI does not have an opaque structure. The FPI regulations 2014 were amended to provide that the term ultimate beneficial owner would mean the beneficial owner for the purpose of the PMLA with effect from December 31st, 2018. By this amendment, it became abundantly clear that when the FPI regulations 2014 require identification of the ultimate beneficial owner, it meant identification of the beneficial owner as stipulated in Rule 9 of the PMLA rules. If these stipulations were not complied with, it would lead to consequential action of potentially cancelling the registration of the FPI, removing its right to invest freely in the Indian stock market. Para 13. What is even more piquant is that on August 21, 2019, SEBI decided to delete the regulatory stipulation altogether. The deletion was made accepting a slew of recommendations made by an expert working group appointed by SEBI in a report dated May 24, 2019. The working group's recommendations were also put out for public consultation, including consultations with all other agencies, including the Department of Revenue, Department of Economic Affairs, Reserve Bank of India, and Ministry of Corporate Affairs. The recommendation of the working group stated as follows. All FPIs need to provide beneficiary ownership details, and those who fail to provide BO details, including on account of bearer shares, cannot deal in securities market in India. Thus, there is no need for separate definition of opaque structure. The opaque structure class may therefore be removed from FPI regulations. Para 31. The FPI regulations 2014 were repealed and replaced by the SEBI Foreign Portfolio Investor Regulations 2019 with effect from September 23, 2019. This version continued without any change to the amended position in this regard. Legal scope of the term beneficial owner under PMLA. Para 32. As seen earlier, the term ultimate beneficial owner was given the meaning given to it under the PMLA. Towards this end, circulars issued by SEBI to invoke Rule number 9 of the PMLA rules. They refer to identification of natural persons who ultimately own or control an FPI, but state that such persons should be identified in accordance with Rule number 9 of the PMLA rules. Para 33. In terms of the PMLA rules, the determination of such ultimate owner, controller, or person on whose behalf investments are made by the entity in question is to be determined for any owner of such entity in question holding 25% or more of such entity. The 25% ownership threshold to identify the ultimate beneficial owner under the anti-money laundering law was lowered by SEBI in its application to FPIs to 10% ownership threshold. This is quite consistent with the Companies Act 2013, which too requires filings of ultimate beneficial owners for shareholders holding more than 10% in an Indian company. Para 34. On the strength of this requirement in 2019, SEBI did away with the regulatory stipulation against having an opaque ownership structure. The thinking evidently was that if every FBI was required to provide information about beneficial owners in respect of owners holding more than 10% of the FPI, there was no need to have a massive requirement to know the ultimate beneficial owner of every single owner of the FPI. Para 35. The complexity emerges from the fact that in FBIs that are collective investment pools such as mutual funds, participating shareholders, that is the contributors provide the funds that are placed under the control of the controlling shareholders, the fund managers. Para 36. If a promoter were funding such participating shareholders, the simplest form would be to indirectly fund it by investing in the pool. But the key would be to examine if the person funding the pool has a right to control decisions on behalf of the pool. Like the video, subscribe to the channel, give your comments. Thanks for watching.